talking about limitations and exclusions. One that you might come across and which really needs a bit of an interpretation is an exclusion or limitation on a party's rights to recover lost profits. So that's money that they might otherwise have recovered except for that other party's breach. And this takes us back to a case from 1854 called Hadley and Baxendale. And this set a sort of two-pronged test. It's known as the two limbs of Hadley and Baxendale. And these are the two different types of damages that could be recovered in the event that somebody breaches a contract. And this covers, and I'm going to read from my contract law textbook at this point, damages which are either arising naturally, that is according to the usual course of things from such breach of contract itself, first limb, arising naturally, or such as may be reasonably supposed to have been in the contemplation of the parties at the time they made the contract as a probable result of it. So reasonable contemplation, that's second limb. So that is what's referred to as direct and indirect loss. So the first one, direct loss. Imagine you've got a faulty fridge. The direct losses is repairing or replacing the fridge. Indirect losses relate to the goods that are inside the fridge, maybe loss of a catering contract because you didn't have access to a fridge that was necessary. So those are the sorts of categories of loss. Now, lost profits is important because you often see exclusions of lost profits, and these can arise in a certain number of circumstances, particularly on termination or omission of a scope of works. Now, if they omit works from your contract, then you're entitled to some form of compensation. But if they've excluded your ability to recover your lost profits, it's difficult to imagine how they can compensate you, because you've lost the opportunity to do something, and the loss of that would be lost profits. Now that's a direct loss as a result of their acts in removing your right to continue the whole of the scope. And in relation to termination, again, quite often you'll be looking for lost profits as a form of compensation. Now, lost profits can be both direct loss and indirect loss. And a good example of this is a case to do with hotel minibars. The software for the hotel minibars didn't work, but the software company had excluded any lost profits from the hotel's right to bring a claim for compensation for breach of contract. The problem was that was all that they had by way of losses. It was the difference between the can of Coke as they bought it to wholesale and the can of Coke that they charged you when you needed a Coke either at 6 o'clock in the morning or midnight, whichever. That was the purpose of the contract, to create profit for the hotel company from these small items that go in the minibar. Now, the court said if they excluded all rights of the hotel to recover lost profits, that reduced the contract to a mere statement of intent. That is not something the law looks well on. In fact, it frowns very heavily on reducing our contract to a mere statement of intent. And when it says a mere statement of intent, what it means is that although you've promised to do something, if you don't, well, there aren't any consequences. You have no obligations. You won't compensate the other party. That's basically a promise that cannot be relied upon or legally enforced. So those losses of profit were direct losses. Now, indirect or direct, it's really important to look at the clause that refers to lost profits to see whether it's using it as a whole, any lost profits, or whether it's using it as a category of indirect losses. Now, you may be able to say, well, okay, we don't want compensation for our indirect losses, the profit we would have made on that catering job relating to the broken down fridge. But it could be that it's trying to cover all of your losses, whether direct or indirect. And then you need to really keep your alert, because those sort of limitations, particularly when they relate to termination, omissions of scope, and things like other willful breaches by the other side of their contract, can be really, really harmful when it comes to trying to recover from some form of compensation from someone who has already breached your contract. So pay attention to lost profits, try and work out which one it's thinking of, try to get those clauses excluded and taken out of your contracts where relevant, because they can do an awful lot of harm and are subject to serious misinterpretation.